Welcome to Business Talk with Meghan McNulty, the podcast that takes you behind the scenes of business success and reveals the strategies, insights, and stories that drive these professionals to thrive in the ever-evolving world of business. Whether you're an established entrepreneur, a seasoned business owner, or simply fascinated by the world of commerce, this podcast is your front row seat to learn from the best. Each episode, Meghan will bring you engaging interviews with professionals from diverse industries who will share their triumphs, lessons learned, and the insights they've gained along the way. Hi, Janani. How are you?
I'm doing well. How are you? Thank you for having me.
Thank you for being here. I want to introduce you to everyone listening. So Janani Rana is a family law attorney who specializes in litigation, and she works with several business owners or people that own their own businesses or are professionals. So we're lucky to talk to her today. And I'm going to start out asking you a couple questions about your background. I'm wondering, how long have you been in practice in family law, and particularly with cases involving business owners and divorces?
So I've been a family law attorney for about 14 years. I've only ever practiced family law. I became a certified family law specialist about 7 years ago, maybe 8. You lose track of time. But I would say about 80% of my practice involves a spouse that either owns a business, is significantly self-employed, or owns an interest in a business. And this includes people who are doctors, and so they are self-employed, but maybe run their income through an S corp. It includes maybe a partial owner of a tech company or a widget factory. So there's a wide range of, we call them business valuation issues. And I would say about 80% of my practice deals with those.
Amazing. So a lot of business owners, entrepreneurs, and professionals have a level of complexity to their assets. And when they get married and then unfortunately get divorced, half of the Americans end up getting divorced nowadays. What's your familiarity with involved with dividing the assets when you own a business or you're a professional with an S corp?
In a family law divorce, and every divorce is slightly different, and every county is slightly different. So my firm, we exclusively handle Orange County cases. So my practice, my most recent experience is limited to Orange County divorces. And that's important because there is sort of a formula and an approach for how the judicial officers are taught to handle business valuation issues in Orange County. That is perhaps slightly different from LA or San Diego, or if you leave California where you don't have community property potentially, it's completely different, right? So in Orange County, we aren't necessarily dividing the business. We are, one, characterizing the business as either separate property or community property, and then we're valuing that business or valuing that interest in the business. And then the other spouse, typically the non-owner, non-operator spouse, is going to either get a series of assets or an asset that is equal in value, or a cash payment to buy them out, quote unquote, of the business. And so I would say it's a two-step process. Step one, characterize. Step two, value. And I would say that business valuation is a really complex, very case-specific area of law that requires the retention generally of financial experts. And that includes, but isn't limited to, the family law forensic CPA or appraisers or a reasonable compensation expert. Sometimes you have a factory that owns equipment. Perhaps you need an appraiser for the valuation of that equipment. So strategically and early consideration of the business characterization and valuation issue, I think, is really important to saving time, saving fees. You want to address this sort of holistically and early. And I emphasize that, and I'll probably say that over and over: early retention of the CPA, early strategic consideration of these issues. It's so important to how you effectively handle the business valuation issues in a divorce.
When you're doing the evaluation, it's good to get ahead of it sooner rather than later. How is the date of valuation determined? Because people argue that, oh, we got married and it wasn't worth anything, and now it's worth a lot of money. And one spouse will argue, I contributed to creating that with you, even though they're not
Yeah.
in the business.
So data valuation is probably one of the key issues in a family law business valuation issue. So I would say, but before you get to that, let's talk about character. So I mentioned earlier there's separate property versus community property. So community property, just I don't want to get too lost in the weeds in the law, but it's so important to understand this. Community property in California is an asset that was acquired or formed during the marriage as a result of efforts by the spouse during the marriage. So, if the business was formed prior to the marriage, or if the ownership interest was acquired prior to the date of marriage, then it's a separate property asset of the owner's spouse. And so there is law that says specifically how do we determine if it's separate or community? If it's community, the entire business or business interest is going to be valued, and then the other spouse gets bought out or equalized. But if it's separate property, so it's a business that the spouse owned prior to marriage, that he or she operated during the marriage, and perhaps it appreciated during the marriage, it went up in value during the marriage, then there's a different analysis. And courts can use different formulas. There's a lot of cases that talk about how courts have a wide variety of discretion to value the appreciation and how do you sort of reimburse the community. But what's important to know is that we're not changing the character of that business. It remains a separate property business with a right of reimbursement to the community for that appreciation. Why? The community, absent a prenup, and you and I will talk about prenups in a bit, I'm sure, but absent a prenup, the community is entitled to the benefits and the value arising out of a spouse's efforts during marriage. So if my husband and I are both employed during the marriage and we don't have a prenup, and I'm working on my business, and I'm taking the income from my business and I'm reinvesting it into my business, well, my husband, he's entitled to some of that reinvested income, reinvested value, because otherwise I'd be putting it into our joint account, putting it into joint assets, I'd be growing the community estate. So there's a right of reimbursement that goes back to the community. But to your question, when do we value this interest? Typically, a business or a business interest is going to be valued as close to date of trial as possible. So if two people decide on January 1st, 2024, that the marriage is over and they want to separate, and one of them that day files a petition for divorce, they may not get to trial in Orange County for years. And that's because of a severe backlog of judicial officers. We don't have that many judges, and we
Wow.
don't have time for the judges to hear the cases. So you've got a 2-year gap between the date that you separate and the date of trial when the business will ultimately be valued. And that's important because perhaps that owner spouse is continuing to work on the business after separation. If I'm a sole proprietor OBGYN and I develop some new technology after separation that allows me to really enhance the quality of services I provide to my patients, and therefore my customer base skyrockets, my business skyrockets, my revenue skyrockets, well, that was all done post separation. Does my spouse get to share in that? And so the data valuation is something that parties can negotiate and ask that the court consider an alternate data valuation, perhaps for a self-employed spouse or a small business where the personal efforts of the spouse are appreciating that business value. Maybe you do an earlier business valuation date. If you're just one of 50 owners in a large tech company and your personal efforts aren't really causing any value changes in that business, date of trial is probably when that business or business interest is going to be valued.
So you mentioned Orange County. It's is specific. There's nuances to Orange County. And can you kind of go over that? Because I never realized that it depends what county you are in, and you really want an attorney that's specific with the county and their certain rules when it
Yeah.
comes to family law.
Yeah. And I wouldn't say there's huge differences between Orange, San Diego, and LA, but Orange County, well, so let's back up. So there's generally three approaches to valuing a business: the income-based approach, the asset-based approach, and what we call the market approach, looking at comps. And in the income-based approach, you're looking at the earnings of the business and applying a capitalization rate essentially to the earnings or the cash flow stream. How many years, how long can I expect this income to continue? The asset-based approach is for a business that is asset heavy. You're looking at the assets of the business, the debts of the business, and you're valuing the business based on that. So that might be, as an example, a shell corporation that owns real property. It's not so much that the corporation is doing a whole lot of work. The rental income, the real property is sort of self-sufficient, and it generates income, and its income pays for its expenses. So you're looking at the value of the assets of the entity as opposed to the actual entity itself. And then the third approach is market, where you're looking at comparable sales, recent sales, businesses that are like in size, in composition, in product, geography, in revenue, in market restrictions, competitors. And you decide, well, based on these recent sales of these comparable businesses, what is the value of this business? So Orange County is unique, and generally it's difficult to convince judges to use the market approach. And so in Orange County, most businesses are going to be valued through either the income approach or the asset approach or some combination of those. And there's a lot of, I mean, we could spend hours talking about
Right.
income approaches and asset approaches, but the family law court in Orange County has to consider what's called goodwill, which is this idea that there's an expectation that someone's going to continue to patronize your business. And that goodwill, this expectation of continued patronage, is there's a formula and there's a way of calculating it in Orange County. And so what I would say is, if you're looking at income and assets generally and not market sales, not comparable sales, you as a business owner should think, how am I going to justify my expenses that offset my income? How am I justifying them as reasonable, non-recurring or recurring, discretionary or non-discretionary? How am I going to be able to characterize these? What records do I need? What experts do I need? Who am I going to call as a witness to say that this crazy marketing campaign that I launched in the year of separation is necessary for the growth of my business, as opposed to a way to just sort of hide income, right? And so think about those questions as the business owner. How do I justify my expenses? What are my assets on the books? Are these necessary for the operation of the business? Because if they're not, in a family law valuation, there will be adjustments to normalize the earnings, to remove non-operating assets, and to also potentially add back extra working capital that isn't necessary, that you keep in your business that maybe you don't need for the operations of the business. So those types of things you can think about.
Interesting. I'm still like so curious about the Orange County. Can we just go back to like Orange County? What's unique about maybe us versus San Diego and LA
Like I said,
here? Yeah.
I wouldn't necessarily say it's too different in San Diego and in LA and
Okay.
Orange County. I will say that Orange County judges, there's fewer market approach. There's fewer judges willing to use the market approach. And
Okay.
that's generally because we're a smaller county,
Okay.
fewer comparable sales. And so we're going to look more to the income and asset approach. But a judge can do whatever he or she wants in his discretion. That's reasonable. That's based on empirical admissible evidence.
I'm kind of going to go into legal strategies and options. And I'm wondering what legal strategies you recommend for protecting business assets during divorce proceedings.
The first thing I would say is think about this valuation process as preparing your business for sale. If you're readying the business for sale, what would you do to normalize your expenses? You might think about what personal discretionary expenses are being paid through the business that are permitted by the IRS, but are going to be added back by an Orange County family law judge. So maybe you're paying
Okay.
for your insurance, your car expenses, your garage or storage fees. Maybe there's travel, entertainment that the IRS permits, but an Orange County family law judge says, I don't really think that's necessary for the operation of your entity. Maybe you've got some faux employees. You've got your kids or your spouse or your cousin Bob on payroll, and Bob has never worked a day in his life at the business. Maybe you're running your kids' school supplies through the business as office supplies. Maybe you're paying for legal fees that are personal in nature, but you write them off as business legal fees. Think about things like depreciation. Those get added back in divorce in Orange County. Major capital expenditures can get added back as non-operating expenses, non-recurring expenses. And so that would be the first thing to think about. How am I going to look at my books? How am I going to normalize this income? If I were doing this for a sale, what would I do? What could I expect to be added back? And that's good because you want to set your expectations reasonably, right? So that kind of leads into the next thing, which is in a family law action in Orange County, in all of California, both spouses are fiduciaries to one another. And so you will be sharing the books and records of your business, even a separate property business. And that includes bank statements, credit card statements, backup, checks. Accountants get to interview key employees at the business. Your QuickBooks generally gets turned over. Your key employees and you may be asked to appear for a deposition. So think about handling bad AR. Think about making sure you have books and records. Do you want to clean up those books and records? If you're a small GC and you've got a couple of employees and you've been operating in paper for decades, because that's just the way you work, you may want to think about digitizing and transferring your records to some sort of online accounting software. Consider what expenses you're going to be paying this year. Are they necessary? Will they get added back? Is there a way to justify them? Consider if an acquisition or a buy-in or a buyout or a sale needs to be done, and if that will impact value. Now, a lot of these considerations, you're thinking, how does this person do it? And that's where that expert comes back in. So strategically finding a family law attorney and a family law forensic CPA that will guide you through these questions, that maybe spends a couple hours as a consult looking at your books, looking at the way that your business operates, and says to you, hey, here are the things you need to clean up. Here are the things you can anticipate. That is so key. It's so important. Now, a lot of people say, can I use my personal CPA? I don't want to hire somebody else. I've got this fantastic CPA. I've been using her for 20 years. She's the best of the best of the best. And I'm sure she is. But if she's not qualified to testify as a family law CPA in an Orange County family law court, you're going to have a huge disadvantage because her testimony is going to be far less credible than the other side's experts. She may not know the pertinent case law. She may not know what family law judges are looking for in terms of add backs or perquisites or how they treat perquisites. Here's a distinction. In Orange County, perquisites are generally treated as non-taxable. And so if you're adding it back because you didn't actually pay taxes on that income that was used to pay your personal expense, it's added back as a non-taxable income item. In other counties, they can be added back as taxable income, which reduces your total income, which reduces your net earnings, which reduces the value of the business and support that you pay on your earnings. So being in Orange County may not be helpful if you have a lot of perquisites. But that appraiser is also going to tell you whether you need additional experts. Do you need an appraiser to value on real estate, to opine on real estate? Do you need an appraiser to opine on machinery or computers? Or do you have intellectual property issues? Do you need a tax expert? Do you need someone to come in and talk about your reasonable compensation for employees? Many owners undercompensate themselves because they're putting that income back into the business. They want to grow their business. Reasonable makes sense during the marriage. As part of a divorce, your reasonable compensation is going to be used to calculate the value of the business. So those are all sort of things that I would say, if you're thinking divorce is on the horizon, anticipate that there's going to be a sale of your business. What would you do to ready your business for a sale? Clean up your books and records. Make sure that you have books and records and then clean them up. Talk to an expert, a family law attorney and a family law CPA. Get everything in order. And you can do this a couple weeks in advance, a couple months in advance, a year in advance. There's no harm in information. I always say knowledge is power. It really is so important to be strategic in a divorce, because if you learn that certain things are going to happen, that certain things are inevitable, it may change the course of your divorce. You may be willing to be more settlement oriented. If you know that you're going to have to turn over those books and records, you may be willing to just share that information proactively. So by the time the divorce happens, your spouse doesn't say, oh, he or she has always kept me shut out of the finances. I have no idea what's going on. I'm the victim of financial abuse and I'm in the dark. No, now the other spouse has been proactively offered information, offered access, because you knew it was going to happen anyway, and you get to wear the white hat. So keep optics in mind.
Okay. Let's say we're in the divorce proceedings and it's not going that great. Are there alternate resolution methods such as mediation or arbitration that might be suitable for resolving business related issues?
Yeah. Well, so family law, we don't generally do arbitration, but I think mediation is a fantastic
Okay.
option. Settlement. So you always want to consider settlement before litigation. Like I said, it takes 2 years to get to trial, sometimes minimum, sometimes longer. And how much are you willing to spend to get before a judge to have your day or days in court? So if you can mediate your case, if you can consider settlement, a settlement conference, retaining a private judicial officer to serve as a settlement officer and opine on the strengths and weaknesses of each side's positions. These are all great ways to save fees. So my firm, we've got a very settlement oriented approach to family law, because I really do think that's the right way to save people money and do good work in this field. You can't be afraid of litigation, so we're all prepared to go to
Right.
trial if necessary. But cooperatively working with the other side early to try to settle your case is important. If you go to mediation, you may want to consider hiring somebody that has family law experience. So there are some really great former family law judges out there that now do private mediation. And it is so worth it to spend several $1,000s on a couple days with them, because that might save you tens of hundreds of thousands of dollars in the long run. So
Right.
yeah, absolutely.
Okay. That's very good to know. How can the divorce process impact the day-to-day operations of the business?
Generally, I would say that the divorce should not operate the day-to-day operations of the business. If you have a standard divorce and one spouse is the owner of the business or owns a business interest, these documents that are going back and forth, think of it like doing a refi. It's a pain in the you know what, and you're constantly submitting documents to your loan processor, your agent, but you're not actually taking time, significant time out of your day to deal with that. Now, this is obviously not true if the divorce gets more contentious, if there's depositions, if your employees are being deposed, then it starts to get a little bit more cumbersome. Sometimes there can be a site visit. But I would say generally your family law CPA is going to be managing the valuation process, not you, not your business CPA, not your employees. The one thing that kind of does arise pretty frequently is the issue of family members that work at the business. And so, if
Mm.
you have family members that work at the business, can this divorce disrupt the day to day because that family member happens to be your spouse, who happens to be the, let's say, CPA for the business? Well, do you fire your spouse? Do you hire a new CPA? Do you give them a pay cut? How do you deal with that? And so that's another reason, you talk to a family law attorney to decide what would be the correct approach. And it's very case specific. What you want to think about is, if you eliminate an employee, you now have greater income that's coming back into the business that potentially increases the earnings of the business, increases the value of the business, unless they're replaced, right? So if you fire your CPA, make sure you don't have an employment lawsuit waiting for you. So you may want to consult with employment counsel. But assuming you fire your CPA for cause, there's a good reason, not that they're your spouse and you hate their guts, but you fire your CPA, you're probably going to have to replace them. So maybe it makes sense to continue allowing the spouse to work at the business. It also shows the court that you have nothing to hide, that you're a clear, level-headed person, you're reasonable, you're trying to act in the best interest of the business. And so again, from an optics perspective, it may not make sense to fire that employee, that's that family member employee. So generally no disruption to the business. Work with your CPA to make sure they're doing the work, not you, not your employees, but talk to your lawyer about how to deal with family member employees.
Okay, so what are the potential outcomes of dividing ownership or interest in the business between spouses?
So if the business is community, and absent, I would say, any unique circumstances, you're going to award that business to the operating spouse. If both parties operate the business together and they each want it awarded, the court's generally going to award this business to the spouse that's more critical to the continued operation of the business. The courts disfavor what we call auctions, bidding wars for the business. So there's going to be testimony presented as to why husband or wife or wife or wife should be awarded this business. And whoever's more critical to its continuation, to its continued success, probably is going to get it. Rarely will a judge in Orange County, I would say in California, award a business jointly to the parties. It'll go to one or the other. And the reason for that is you're almost essentially guaranteeing future litigation. If these two spouses that can't stay married continue to own a business together, there's going to be some litigation, and the courts don't want that. That's a disfavor approach. Now, if both parties desire to own the business together, sure, family court will permit that. If you have a business that's the separate property of one spouse, that spouse is going to get it. So that's pretty straightforward. And I would say almost never will your business be ordered sold. So when we talk about dividing the business, it's kind of a misnomer, right? We're not actually dividing the business in a divorce. And people talk about dividing assets in a divorce. Really, what we're doing is we create a balance sheet. Some assets go to spouse one, some assets go to spouse two. And when there's a disparity in the value of the assets going to spouse one versus spouse two, we equalize the spouses. And we can do that by moving assets around to create an equal, equitable division, or we can equalize the spouse with lesser assets through a cash payment, a buyout.
Okay. Are there, what kind of tax implications are we looking at when transferring or dividing the business assets during the divorce?
So generally none, because in a divorce, the IRS says that all assets are transferable without incurring any gain. So there's no gain that results as a result of a transfer in a divorce. And so if spouse one keeps the business, let's say worth $1 million, and pays spouse two $500,000 in exchange for keeping the business, neither spouse sees any sort of taxable gain as a result of that process. However, what I would say is talk to you. This is where you go back to your personal CPA and say, hey, my business was valued at $1 million in the divorce. How does that impact me in a future sale? Does that change my basis for purposes of a future sale?
Okay. Now, what about financial considerations such as alimony, child support, or property division? Do any of those things affect the business?
Yeah, I would say it's sort of this kind of double dip issue. So when we think about valuing a business or a business interest in family law, generally, since we're using that income or asset approach or some combination thereof, we are looking to the net earnings of the business. Those net earnings of the business are also going to be generally paid to the owner or operator spouse and serve as the basis for calculating child support and spousal support. So we have in family law the unfortunate double dip issue. That same income stream is going to be counted twice. One, you're going to pay support on it. And then two, that same income stream is getting capitalized for purposes of determining a business value that you then buy your spouse out of. And it's an unfair double dip that exists, and there is no real solution to that issue right now, unfortunately. The court uses the same, I would say the court looks at it as using the same fact for defining two different obligations, a support obligation and a property obligation. But generally, I would say my business owner clients feel otherwise. And I will say it's inequitable in a lot of ways, but unfortunately, there's no solution to it right now.
So let's talk about protecting future business interests. Are there legal provisions or agreements that can be put into place to safeguard the business from future marital issues?
Yeah, I would say two categories of things to consider are buy, sell, or shareholder agreements, and then estate planning and premarital agreements. So, buy, sell, shareholder agreements generally are not controlling. So, if you've got a buy, sell agreement in your business that says, hey, this owner is going to be compensated X upon withdrawal, that generally is not controlling for purposes of the family law valuation. However, they can have more weight if there's been a recent sale. So it sort of corroborates that buy sell agreement. They can have more significance or weight if there's a recent withdrawal or a series of withdrawals, or if the non operating spouse signs it. Perhaps if the non operating spouse signs it with the opportunity to review books and records, with the opportunity to consult a CPA. And there's kind of different case law on this. I would say the buy sell is something you consider. You talk to your family law attorney about how to make it as strong as possible, and you work with your business attorney to make it as tight as possible. But you want to think about, how do I prove that this buy sell is legit in my divorce? Estate planning or a premarital agreement might be a better, neater way to do it. And so careful estate planning can relieve so many of the headaches that we see associated with business characterization. If you've got a business and it's kind of funky as to whether it's separate or community, or you really want to preserve that it's separate and waive that community right to the reimbursement, estate planning is key. A neatly drafted premarital agreement that states explicitly, after the proper disclosures have been done, after both parties have opportunity to consult with counsel, that the community is not entitled to a reimbursement as and for any appreciation of the business during the marriage, even if that spouse is just working day and night at the business. That might alleviate the problem of characterization, valuation, and kind of dealing with all of this. You want to make sure you use a good lawyer. My firm doesn't even do prenups because of sometimes that malpractice risk associated with them, because they can be set aside when they're poorly drafted. So we love to refer people to great lawyers that do premarital agreements. So I always tell people, call me, I will get you to the right home. I don't do them myself. We don't do them ourselves, but you want to make sure you've got thoughtful estate planning and potentially a premarital agreement.
In
Now,
place.
when you do all of this, you also want to think about sort of this idea of, how do I prove it's separate property, right? So if your business was gifted to you by your parents, or if your interest was acquired by way of some note that you received and then was forgiven over some number of years, how do you prove that this is your separate property business? So those records, if you work with an estate planning lawyer and a family law attorney thoughtfully prior to marriage, those records you can incorporate into your prenup. You can incorporate into your estate plan. Have the other spouse sign, notarize, review them, right? So just be a little thoughtful is what I would say.
That's really good to know. A lot of this information is extremely helpful, and I had no idea on some of this stuff. So we talked about like basically protection in case of future divorce, and the planning is important. Do you have any final thoughts on the business valuations during divorce, or anything else that they should keep in mind if you're a business owner and a divorce comes up?
Yeah, I would say that valuing the business or the business interest is a surprisingly unpleasant task in a divorce. And most people are just unaware of how unhappy it's going to be, what a process it's going to be. And so consulting with experts early is important, but also in the divorce, just turn over those books and records. Don't play the games. Don't create AR. Do the right thing, because the incentive is reduced fees. The incentive is reduced litigation. The incentive is getting out of the divorce with closure quickly. You don't want to spend money on experts and back and forth discovery and motions to compel. Uh, those fees will eat up your estate, will eat up your savings. And most divorce lawyers make plenty. You don't need to spend your money on them. You want to save that money for your children, your family, your future. Um, the other thing to consider is that there is a family code section that states that there shall be a fee award when there's a disparity in income or access to assets to pay for fees. So if you're the business owner and your income is substantially greater, if there is a disparity between your income and the other spouse's income, there's probably, almost likely, going to be a fee award payable by you. If you know that, maybe offer some fees upfront for them to hire their own expert, so they have the opportunity to review books and records. And you, on the other hand, proactively work with your CPA to provide them with the information they need to do enough of an analysis where everybody feels comfortable to reach a deal, right? Being forthright always minimizes the likelihood that people feel uncomfortable, like you're hiding something. So being forthright, being proactive with that information is good, because it saves you, probably as the spouse earning more or with greater access to fees, it saves you in fees. There are also consequences in family law for doing things like breaching your fiduciary duty, concealing income or information, concealing records, disposing of records, non-disclosure. They're all sanctionable, and sanctions can be hefty. And again, sanctions can eat up the estate. And so I would say it's just best to cooperate, turn over documents. And if you're a business owner spouse that's listening to this, just spend an hour talking to a family law attorney. Take a couple years tax returns to that attorney, have them walk through your returns and talk to you about what they see as reasonable adjustments to your income, as reasonable consequences of your business decisions. Those might all be fine decisions during the marriage, but what's going to happen in the divorce? Make sure that this family law attorney that you talk to is familiar with business valuations. Ask them how many cases have they handled with a business valuation issue? How many cases have they taken to trial with a business valuation issue? How many times have they deposed an expert? How many times have they deposed a business owner spouse? How many business valuations have they even seen?
Right.
And so asking these types of very specific questions of your attorney will help you find the right lawyer, the right fees, and the right structure and the right mindset to help you resolve your case quickly.
Amazing. This has been so much information, Janani, and I
Oh,
appreciate you being here. We should do this again. I'm
happy
sure
to.
lots of business owners will find this very valuable, and I think we should do another one on, the pre-planning and your
Yeah.
advice that, from, it sounds like the key here is making sure you've pre-planned all these different scenarios, especially if you are a business owner and you have other business partners. It's important to do your due diligence and make sure everything's set up correctly. So thank you.
You're so welcome. You're very welcome. Thank you for having me.
And,
Pleasure to be on today.
and I hope to do this again very soon.
Sounds good. Thanks, Megan.
Thank you. If you've enjoyed today's episode, please consider subscribing to the Business Talk podcast and leaving us a review on your favorite podcast platform. Your feedback helps us grow and improve. Thank you for joining us today. This has been another episode of Business Talk with Megan McNulty.